Welcome to the Generis Show, your unique perspective on all things related to your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment 1, we'll be talking about Zoom interrogations, the collateral consequences of criminal convictions, and the federal police tucking their tails and running away from the Oregon protesters. In segment 2, we'll be exploring the concept of suspicion as currency. In the advent and proliferation of online cloud-based monitoring apps that law enforcement agencies quietly use to support search warrants, arrest warrants, indictments, and surveillance of you and your personal life. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, or YouTube. And make sure to follow us on social media at TLOBJ on Twitter, Instagram, and TikTok. Facebook.com/Central Ohio Criminal Defense is our Facebook page. Last but not least, you can always turn to TLOBJ.com for more information about your civil rights in the criminal injustice system. Erica, did you see in the news this week, our conversation about interrogations has been expanded and moved to online chat rooms with the Marshall Project story about police officers using Zoom and other video call services for interrogations and investigation.
That is so interesting. I never thought I'd see the day. Did you?
You know, I really didn't, because police rely so heavily on that in-person contact. Like we discussed in our prior episode, that physical space intimidation tactic, and then the tactics used in the Reed technique, where they claim that they're essentially human lie detectors, really relies on in-person close contact. And I really did not expect to see COVID-19 accelerate the changes to investigative techniques, at all, period, let alone law enforcement actually thinking that protecting vulnerable populations, honestly, they're probably thinking about themselves, would be important, in this time of crisis.
Yeah, I mean, I guess whatever their reasons are, it's going to be better all around for everyone. But what about the custody issues that we discussed in our episode last week about confessions?
So this raises a really interesting legal issue about how we define custody. And you'll recall from our discussion about Miranda that typically custody and whether an interrogation is custodial or non-custodial is one of the most hotly contested, hotly litigated topics in any confession case. Was a statement made in custody or not? Now, if you're not at the police station, but rather on a Zoom call or on a Skype call, what is the proper analysis to determine whether a reasonable person would feel free to disengage from that conversation? Bottom line is this: if you're talking to a police officer and you didn't call that police officer for help, you need to stop and call a lawyer. #NoTalk.
I mean, that makes a lot of sense. Do you think that some people might feel like they're being rude by stopping, especially when they're on a call? I mean, it seems like it's a whole nother ball game for them.
Well, I think you're absolutely right, Erica. There are a lot of factors to this, and there are studies being done right now in universities about how people feel that they aren't free to disengage, even though they're not in the same room as a police officer, even though they're on a video call with a police officer. They feel that pressure, they feel the intimidation, and they feel that submissiveness to authority that really are lodestars of police interrogation techniques and their designs to get people to extract confessions out of people, whether they're truthful or not.
Well, it's going to be interesting. I mean, they have to rewrite their book on how they interrogate people over Zoom to get the same types of results. And I'm not sure that that's going to be possible.
I think you're absolutely right. I think there's going to have to be an overhaul of how police do this work. and not just because of the pandemic. Erica, since 2015, the Collateral Consequences Resource Center has been doing research into the collateral consequences of criminal convictions. And they recently issued a new report demonstrating both a national trend towards expanding the right to vote through changes in law and policy. 17 states, including the District of Columbia, have eliminated or limited the disenfranchisement of people convicted of criminal offenses. And they've just issued a new report about how states disenfranchise people who have been convicted of crimes, and how states strip citizens of their firearms rights, their Second Amendment rights, based on the conviction of crimes. Now, you may remember a couple of years ago, Florida citizens in a statewide referendum repealed laws on the books in Florida that made illegal for people who had been convicted of felonies to vote. So the people spoke up. They said, we want the felons to be able to restore their voting rights. And now the Florida legislature is chipping away at that because Southern lawmakers don't want people to vote. Beginning and end of conversation right there. The current litigation is the result of this legislature clawing back the free will of those Florida voters and trying to take away those civil liberties of people who have been convicted of crimes.
Well, I mean, these are very interesting points that you're making, but there are a lot of liberties lost when someone is convicted of a crime. Why shouldn't they be denied the right to vote?
So, Erica, voting rights are critical in our support for the Black Lives Matter movement and for restoration of civil rights for minorities across the board. Obstacles to voting have a deep history in Southern Jim Crow laws, and therefore are tools of systemic institutional racism. Voting is a process of deciding policy that applies to everyone, felons and misdemeanants included. Having a say in how their lives are run is just as important to them as it is to you and me. And it should be important to the rest of us. They provide a unique perspective on how the criminal justice system or the criminal injustice system runs from the inside. Those people are important to keep involved in our civil processes and keep them invested in civil society.
So you said the report was about voting rights and Second Amendment rights?
That's correct. So in every state except Vermont, the right to possess a firearm is lost after a conviction for certain felonies and some misdemeanors. The Restoration of Rights Project has an online chart showing how complex this area of law is and how complex and difficult it is to have your Second Amendment rights restored after a criminal conviction. Because federal law superimposes another layer of regulation on firearms possession after a conviction. Because the right to possess a firearm has a degree of constitutional protection, federal constitutional protection, even for people who do have a conviction. Now, restoration of voting and firearms rights is critical, not only because these are constitutional rights guaranteed to American citizens, but also because people can be charged with and convicted of new crimes simply for exercising those constitutional rights after having had a criminal conviction.
Are voting and Second Amendment rights the only collateral consequences of a criminal conviction?
Absolutely not. This is one of the most valuable reasons to have a criminal defense attorney on your side if you're accused of a crime. Because even if you're guilty of the crime, it's important that you know what the long-term consequences of your conviction are. Loss of the right to hold public office, loss of your state-run pension, loss of the ability to serve on a jury are broadly applied to almost every felony conviction. However, there are also certain types of convictions and certain classifications of crimes that can also result in your right to hold a license, participate in a particular job, or even have custody of your own children. So engaging your criminal defense attorney in a discussion about what the collateral consequences of your conviction is just as important as discussing what the direct consequences of your conviction are, and what the defense is available to the allegations against you are.
Wow, that's really interesting. It makes me feel like people should take a second look at whether or not they're going to use an attorney for their defense in some of these cases, because not only does it mean that they might lose a few rights, I mean, it sounds like they're going to lose everything for the rest of their life if they don't take care of it properly, especially if it's a wrongful conviction.
That's exactly right, Erica. The possibility of an erroneous conviction of an innocent person is very real. B, conviction for an offense that is a higher level, a higher degree, an enhanced offense is an even more real possibility. And last but not least, being able to engage in negotiations and discussions with the prosecutor to try and limit some of the collateral consequences and the direct consequences of a conviction is a critically important aspect of the criminal defense process. Some individuals that are likely to need criminal defense attorneys are the protesters in Portland, Oregon. Over the last several weeks, federal authorities have been invading that city and disappearing people into unmarked vans, holding them in unknown locations, interrogating them, and sometimes releasing them without charge, sometimes issuing charges against them. However, on July 29th, Oregon authorities announced the withdrawal of those federal law enforcement agents from downtown Portland. While the details of that agreement remain unclear, it's predicated on the understanding that the Oregon State Police Department will step in and ensure the safety of the federal district court in Portland, Oregon. Now, these federal militarized tactical teams arrived in Portland, Oregon on July 4th, and they've been popping up in cities across the nation as Donald Trump expresses a desire to crack down on the Black Lives Matter protests. They immediately employed violent and aggressive tactics, which resulted in some pretty compelling images of protesters being shot, a Navy veteran being assaulted with a baton and having his arm broken as he tried to engage in a civil conversation with these federal police officers, and walls of mothers, nurses, and veterans standing in solidarity and protection of the Black Lives Matter protests.
So, who are these federal agents? I mean, I've been seeing this on the news too, and it's super scary. Like, it doesn't sound like they are from an official organization. So, I'm so curious.
So you'll be interested to know that there is no set federal police agency. There's the FBI that engages in investigation of federal offenses. There's the DEA, which investigates and enforces our drug laws. There's Immigration and Customs, and they have a very obvious and particular job under the federal rules. But this team was made up of ICE agents, US Marshals, and a Border Patrol tactical unit in what appears to be an effort to to conglomerate a federal police force. Now, we don't have a domestic security service. And in fact, this is something that was discussed in the wake of 9/11. In the wake of that, you may remember that ultimately the Department of Homeland Security was created. But the legislature at that time specifically rejected a federal Stasi-like police force because they saw it as a means of oppression and potentially going down the road to an authoritarian state, fearing a leader who may employ that police force for their own political gain. In this case, the Department of Homeland Security is often deployed or is being deployed to monitor what really is activity that should be monitored and policed by the states. The 10th Amendment to the United States Constitution secures specifically to the states that which is not specifically given to the federal government in the articles of the Constitution. So the Secretary of Homeland Security and the Attorney General are trying to backdoor this police force in by using the Department of Homeland Security and what's called the 100-mile rule to say that the Department of Homeland Security, these ICE officers, these US Marshals and Border Patrol agents can police this area because Portland is within 100 miles of a quote unquote border, in this case being the Pacific Ocean. In a way that really flies in the face of what Congress explicitly rejected when it created the Department of Homeland Security 18 years ago.
Wow, that's a really interesting story. I had no idea where they came from, but it's still awfully scary to hear about what they're doing to citizens that are peacefully protesting, and the tactics of throwing someone in an unmarked van and questioning them in an unknown location is just unbelievable to me still.
Well, you know, Erica, I've had an experience of not being thrown into an unmarked van, but being intimidated by police officers. I was in the middle of a trial and I had issued a subpoena to one of the officers who I knew had exculpatory evidence, but he was going to be conveniently on vacation during the time of my client's trial. Fortunately, I was able to track him down, personally serve him with a subpoena so that he had a court order to appear and testify for my client in court. And one night as I was leaving the office late while I was doing trial preparations, a law enforcement vehicle pulled up into my parking lot, turned its bright headlights on, turned its high beams on, and a police officer stepped out of the vehicle and threatened me, threatened my safety, threatened the safety of my law office because I had issued that subpoena and kept that officer from going on his vacation. Now, the way that the lighting was, I couldn't see this individual's badge number, I couldn't see a nameplate, and I ultimately wasn't able to even see the car markings because he then backed out of the parking lot and sped away before I could see the cruiser number. But I've experienced this sort of Gestapo scare tactics, and so this is something that really hits home with me because I know law enforcement officers are willing to engage in this sort of illegal intimidation of people, violation of civil rights, and I just will not stand for it. I think this is a very dangerous time for our country, and I think it's really important that citizens stand up and fight back against this sort of intimidation tactic by violation of our constitutional rights.
I absolutely agree. And I'm very interested to hear what you have to say this week about their surveillance issues. And actually, I guess if you had a camera outside of your office, that might have been helpful at that point, but use some of the tactics against them. But I am interested in hearing about what you have to say. There's a lot of interesting things going on now with surveillance, especially now that a lot of things have gone virtual.
Absolutely. So the expansion of cloud-based surveillance and data apps has mushroomed over the last 2 years, and it's been increasingly relied upon as a tool for law enforcement to fabricate probable cause and reasonable suspicion to search houses, detain and arrest individuals, and ultimately issue criminal charges.
So what types of programs are monitoring the internet for digital crimes?
There are a variety. Directly in the hands of law enforcement, you've got a tool called the Child Protection System. Now, this is essentially a bot that scans file sharing networks and chat rooms to find computers that are downloading photos and videos depicting the sexual abuse of children. 12,000 people have been arrested in cases identified by the Child Protection System over the last 10 years. The system lets police officers on a state and a national level search by county, city, or state, and displays a ranked list of internet addresses downloading the the most number of files. The tool looks for images that have been reported to or seized by police, quote unquote, hashed and categorized as depicting children under the age of 12. This program is provided free to law enforcement officers, and it's used in all 50 states as well as 95 other countries. The information exposed by the software isn't itself enough to make a warrant, or it's not supposed to be. But law enforcement is supposed to use it to help establish probable cause to generate a search warrant or to obtain a search warrant from a magistrate. And before getting a warrant, police are also supposed to subpoena the internet service provider to find out who controls the account, whether anybody at the address has a criminal history, whether any children have access to the network, or the people that live at the house have access to children themselves, and who the users are on the network.
Wow, that's really interesting. So, what's the problem with the police having access to this type of software?
So the problem with this system is that it's both too wide and too narrow. The system scans primarily for file names and hash values. So every file on your computer has what's called a hash value. It's a unique multi-digit number that includes both numerals and letters. And that hash value is a unique identifier to each file on your device. And that applies to your computer, that applies to your tablet, that applies to your phone. Every image in existence has a hash value. And for the most part, as you share images between individuals, you airdrop a picture to your friend, the file will retain the same hash value as it goes from computer to computer. The system is too wide in the sense that any legal pornography that has certain red flagged words, because it's not only looking for the hash values, it's also scanning the file names. So if the file name or file tags have red flagged words like teen or barely legal or Lolita in the title, it'll get flagged and those people will be investigated. Likewise, the system is too narrow because child pornography and the world that child pornography exists is such that the hashed files can be rewritten and redeveloped in a way that changes their hash values, because people that create this sort of illegal material are savvy enough to make those changes. And they're industrious enough to constantly be generating and creating more content. The problem for the average person is twofold. One is people have shared Wi-Fi networks. If the child protection system hits on your IP address, but you live in a house full of roommates or family members, or you have an unprotected network, a Wi-Fi network that doesn't have password protection on it, and your neighbor is stealing your Wi-Fi, or you do have a password protection on your Wi-Fi network and your neighbor is still stealing your Wi-Fi, law enforcement really has no way to identify who and how those images are being downloaded on the network. They can only get so far as the router of that system. So they don't have any way to identify who is engaging in the alleged criminal conduct. The other problem is the impermanence of digital information. If child protection says that you downloaded a video, but police come and don't find anything on any of your hard drives, essentially what they do is they take these devices.
They take these devices and they don't give them back, right?
That's exactly correct. You may never get that device back.
That's amazing. I mean, some of those devices are super expensive. I know I just bought a $5,000 computer myself for all the video work that I do. And I can't even imagine if someone came and took that away. That would be a huge hit for me.
That's exactly right. The police being able to come into your house, seize your property with really no avenue to get those devices back short of a lawsuit against the police forcing their return, can be incredibly financially damaging.
So it seems like the police have some pretty invasive tools, but certainly the citizens don't have something like this, do they?
Well, you'd be absolutely wrong about that, Erica. Citizens do have invasive tools at their disposal. One tool is called Citizen. It's an app that alerts users to nearby emergency incidents and then encourages them to live stream from that scene. The app is presently only available in 10 cities across the United States, but is coming to a city near you soon. What the app does is it gathers geolocated information that's gleaned from emergency police scanners, filtered through the citizen employees, who then compile the incidents and place them on a map. Now, if a user is in that area, that person receives a push notification about the incident, about the law enforcement involved incident, and they're encouraged to go to that incident and live stream what's going on. The Surface has been compared to services like Nextdoor and Ring. And it is similar in the sense that it provides some transparency about incidents to people who are affected by them. Now, this is a rebrand of an app that used to be called Vigilante, which was pulled from the app stores and criticized heavily for encouraging bystanders to intervene in emergency situations, leading to a dangerous situation for really everybody involved. Now, in order for the app to succeed, and here's where it really becomes a problem, is that the app requires user-created content, clickbait, kidnapping children, fires, burning houses, somebody not walking away from a dangerous situation. Now, we know that it's important for citizens to record police officers so that we have a record of their illegal conduct. But what we don't need are vigilante citizens chasing down suspects while trying to video stream and get likes and higher rating on an app system that's designed to promote this sort of behavior.
Wow, this seems like a great way to sensationalize law enforcement and create dangerous situations, more dangerous perhaps than they're already dealing with.
Absolutely. This app called Citizen claims to promote transparency and accountability. And ideally, you wouldn't have to rely on the police officer's perspective. And we do, but do we really need an app with push notifications and a slick editing and emotional ploys to do this? The issue with this in any app, as we'll discuss momentarily, is that it really comes down to what you're agreeing to in its terms and conditions. Internal bias and prejudice confirmations are rampant in the comment sections on Citizen. And they often devolve into stereotyping based on race and classism.
You mentioned terms and conditions, and I'm just wondering, what about these terms and conditions should we be worried about?
So no matter what program you're using, there are terms and conditions that you've agreed to, or you don't get to use the software. So most of us just check yes without ever reviewing the details of that end user license agreement. Now, this is an issue because oftentimes these terms indicate that the app owns the information that you send to it. You don't own that information. The app and its parent corporation can then therefore pick and choose what information it discloses, retains, destroys, or archives about your personal browsing history, your online activity, your geolocation, your home surveillance footage, and your online community participation. And frequently, this information is turned over without any judicial oversight to law enforcement.
So why is it that there isn't a warrant needed to view my Nest and other types of apps that have surveillance footage and keep track of where I am on the internet?
Most of these devices, in their terms and conditions, tell you straight out that they will turn over your data to law enforcement in response to a subpoena. Now, subpoena is not issued by a court. It issues through a court, but it doesn't have any judicial oversight. A police officer can go to a courthouse, issue a subpoena, and these companies will turn over the data. They don't even really have to have an investigation going on. If a police officer in your neighborhood decides that they want to issue a subpoena to your internet service provider, they can do so, and there's very low possibility of them getting caught. Now, that sort of behavior without a reasonable suspicion to engage in that investigation is absolutely criminal conduct. But what's the likelihood that you're going to find out that police officer Bob, who's your neighbor, subpoenaed all of your internet service provider information and now knows every website that you went to, every post that you liked on Facebook, every video that you watch on YouTube? Practically speaking, it's very low. Most of these agencies, most of these corporations have no obligation, and in fact, expressly exclude any requirement of them to let you know that your information has been subpoenaed. So you're never going to find out unless Officer Bob somehow makes a mistake and tells you that he engaged in this illegal conduct. Now, it's important to note that Ring, Amazon, and law enforcement have partnered to share information and provide free cameras to neighborhoods that they want to get into and target. Now, you may think that you're safe because you don't have one of these camera doorbells. Well, think again, because your neighbor's camera can reach your front door. In fact, Erica, I have seen footage from a Ring camera where you could see into the house across the street under the right lighting circumstances. This was at night, where the interior of the house was lit and the window blinds weren't pulled. And you could absolutely see into that house. You could see individuals moving around in that house. You could see distinct bodies and faces in that house from a Ring camera. And they don't need any permission to share or publicize footage captured by a Ring camera. In fact, you don't even need to purchase a video surveillance system to be a part of the growing online neighborhood surveillance network through Neighbors or Ring's Facebook-like app. Many neighborhoods even feature a members-only Facebook page where they share images, photos, even license plates among one another as a basis to arouse suspicion and make accusations against one another.
I mean, as scary as that sounds, why should we care if we don't have anything to hide?
I get this question a lot. Why should we care if we don't have anything to hide? Well, the erosion of our fundamental rights of life, liberty, and the pursuit of happiness as protected by the Constitution, and in particular, in this case, by the Fourth Amendment, is something to worry about. We have a right as homeowners or renters to the undisturbed and unmonitored enjoyment of our private spaces. We're handing over our rights and our security under the guise of defeating crime, but our civil rights are too high a cost to pay for a few convictions of people for loitering or smoking weed inside their house. If you watched Last Week Tonight with John Oliver this week, you saw Chinese neighborhoods with surveillance cameras pointed at every single apartment door. The Chinese police would arrest and interrogate these citizens under the guise of investigating things like terrorism for behavior such as suddenly quitting smoking or exiting through the front door when they usually left their home through the back door. I don't want to live in America where I can be arrested because I decided today I'm going to go out my front door rather than through my garage door. Because now that I've gone out my front door, I'm suspected of being a terrorist. At the cross-section of our digital and daily lives, citizens have to be informed and aware of the many ways they're being watched by law enforcement and by their neighbors. And we have to fight back and stand up and say, this isn't acceptable. And these companies cannot own the interior of our houses. It's just not right.
Well, and with that story too, I mean, they were basically looking to persecute those people because of their religion, and then bring them to camps where they reteach them how to be the way the government wants them to be. And so, yeah, and they could pick any reason that they're looking at you. It could be that they they want to say, oh, hey, Brian might be a terrorist, or someone else might be looking at child pornography, whatever they decide on that day. If they feel like bringing you in, all they have to do is look at the surveillance and find a reason, and find that you're doing something slightly different. And you're right, it's just a super scary sign of our times.
That's absolutely right, Erica. It is a super scary sign of our times. Now, I want to thank you for joining me. And to everybody out there, if you want to be informed about how police and private corporations are partnering for patterns of digital peeping, if you want to learn about police and government accountability and all of your constitutional and civil rights, check out tlobj.com or find us on facebook.com/Central Ohio Criminal Defense, at tlobj on Twitter, Instagram, and TikTok, and find our information using the hashtags no walk, no talk, and no blow. Make sure you like and subscribe to our channel. And remember, we'll be back next week with a new sui generis perspective on the next big thing in civil rights and the criminal injustice system, as well as an in-depth discussion about what is probable cause for a search warrant. Erica, my grandpa always told me, don't do anything I wouldn't do when we parted ways. And to that, when I'm talking to my friends and when we're parting ways, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.